PB Taxand Tax Updates. Disclaimer: the following information is intended only to be a guide. It must not be relied on in or applied to specific situation without previously seeking proper professional advice. New provisions on the requirements for tax proxy. The government has issued new regulations governing individuals who may act as tax proxy through Minister of Finance Regulation Number 44, year 2026, which came into effect on July 6, 2026. The regulation was introduced to provide legal certainty, ensure equal treatment, and facilitate individuals appointed by taxpayers to exercise their tax rights and fulfill their tax obligations. Prior to the issuance of Minister of Finance Regulation Number 44 of 2026, the rules concerning tax proxies had already been amended by Government Regulation Number 50, year 2022, which revised the previous provisions. Under those rules, individuals eligible to act as tax proxies included tax consultants, other parties, or family members. With the enactment of Minister of Finance Regulation Number 44 of 2026, the previous regulation, namely the Minister of Finance Regulation Number 229, year 2014, has been revoked and is no longer in effect. The key provisions introduced under Minister of Finance Regulation Number 44 of 2026 are as follows. A. Parties acting as tax proxies. Parties eligible to act as tax proxies include A. Tax consultants, B. Other parties, C. Family, a spouse or an individual related by blood or marriage up to the second degree. Under the previous Minister of Finance regulation, only two categories of individuals could be appointed as tax proxies, that is, tax consultants and employees of the taxpayer. With the enactment of Minister of Finance Regulation Number 44 of 2026, employees of the taxpayer may still be appointed as tax proxies, classified under the Other Parties category. Furthermore, the taxpayer remains ultimately responsible for the exercise of their tax rights and the fulfillment of their tax obligations that have been delegated to a tax proxy. B. Competency requirements for tax proxies. Tax proxies, other than family members, are required to possess specific competencies, namely an adequate understanding of the applicable tax laws and regulations. For tax consultants, this competency requirement is demonstrated by holding a tax consultant license. Meanwhile, other parties must obtain a certificate of registration. The procedures for obtaining a tax consultant license and a certificate of registration will be further regulated under a separate Minister of Finance regulation governing tax consultants and other parties acting as tax proxies. However, as of the publication of this tax updates, such implementing regulation has not yet been issued. One of the most significant changes introduced by Minister of Finance Regulation Number 44 of 2026 is the requirement for other parties to obtain a certificate of registration. As a result, employees appointed as tax proxies will be required to hold a certificate of registration effective January 1, 2027. Under the previous regulation, however, employees who were not licensed tax consultants could satisfy the competency requirement simply by holding either a tax brevet certificate or a formal educational qualification in taxation, at least a Diploma III or associate degree from an accredited public or private higher education institution with an A accreditation. C. Additional requirements for retired/former Ministry of Finance officials acting as tax proxies. Additional requirements apply where an other party appointed as a tax proxy is a retired civil servant of the Ministry of Finance, a Minister of Finance civil servant who resigned before reaching the mandatory retirement age, or a former government employee under a fixed-term employment contract with the Minister of Finance. Such individuals must satisfy the following conditions. A. Have been honorably discharged for Minister of Finance civil servants who resigned before reaching the mandatory retirement age. B. Have never been subject to a severe disciplinary sanction. and C, have passed at least 5 years from the date of retirement, honorable discharge, or the end of their employment term, as applicable. D. Registration of tax proxies in CoreTax. Tax consultants and other parties appointed as tax proxies must be registered in the Directorate General of Taxes Administration System, namely CoreTax. The registration is completed by submitting either a tax consultant license or a certificate of registration. In addition to registration through CoreTax, tax consultants and other parties may also submit the required documents directly to the relevant tax office or tax service, dissemination, and consultation office. Where the tax consultant license or certificate of registration has already been integrated into the CoreTax system, the tax consultant or other party will be deemed to have fulfilled the registration requirement. E. Special Power of Attorney. A tax proxy must hold a special power of attorney, or POA, granted by the taxpayer, either executed electronically or in paper form using the format prescribed in the appendix to Minister of Finance Regulation No. 44 of 2026. Each POA is valid only for one tax proxy and only for the specific tax rights and/or tax obligations expressly stated in the document. A paper-based POA must be submitted directly to the relevant tax office or tax service, dissemination, and consultation office. An electronic POA is deemed to have been submitted once its creation in the CoreTax system has been completed. Where a family member is appointed as a tax proxy, the POA must be accompanied by either a copy of the family card or a written declaration confirming the family relationship if the proxy is not listed on the same family card as the taxpayer. When preparing a POA, it is important to note that the document must specify its period of validity. In addition, where the POA authorizes a proxy to exercise tax rights and/or fulfill tax obligations on behalf of the taxpayer must also grant the necessary access authorization within the CoreTax system. F. Termination of the grant of authority. The appointment of a tax proxy shall terminate under any of the following circumstances. A. The validity period of the POA expires. B. The taxpayer revokes the appointment. C. The tax consultant license is suspended and/or revoked. D. The certificate of registration is suspended and/or revoked. E. The proxy is convicted of a tax crime or any other criminal offense. Where the taxpayer revokes the appointment, point B, the revocation must be accompanied by a letter of revocation of the POA, which must be submitted through CoreTax or directly to the relevant tax office or tax service, dissemination, and consultation office. The revocation becomes effective on the date the Director General of Taxes receives the revocation letter and does not have retroactive effect. Where a taxpayer appoints a new proxy to exercise the same tax rights and/or fulfill the same tax obligations, the letter of revocation of the POA must be submitted before the new proxy is appointed. G. Transitional provisions. Individuals other than tax consultants who hold either A. A tax brevet certificate or B. A formal educational qualification in taxation, at least a Diploma III or associate degree from an accredited public or private higher education institution with an A accreditation, may still be appointed as tax proxies until December 31st, 2026. For such appointments, the POA must be executed in paper form, accompanied by a photocopy of the tax brevet certificate or educational diploma, and submitted directly to the relevant tax office or tax service, dissemination, and consultation office. Furthermore, any POA submitted before Minister of Finance Regulation No. 44 of 2026 came into effect may continue to be used for the exercise of tax rights or the fulfillment of tax obligations in accordance with the terms set out in that POA. Thank you for listening to PB Tax and Tax Updates.